Okay, so um, again, I promised that I would tell you a little bit about myself earlier in the brief introductions. So I've been a law professor for more than 15 years at three different institutions. I've been a law school administrator as a dean for bar preparation and academic success at those same schools as well. I've also been a bar exam consultant for multiple bar review companies. Many of those companies, as Mr. Kim had mentioned during his previous presentation, too. I was a former bar exam grader. I am licensed in the state of Minnesota, where I went to law school. I'm a frequent writer for the American Bar Association. I do maintain my personal blog as, more of a hobby, where I try to sort of connect study tips and bar examination preparation tips, and try to connect it to sort of current events and pop culture. Received my law degree, as I said, from the University of Minnesota. I have a master's degree in science and journalism from Columbia and my undergrad degree from Yale University. So with that, why don't we go ahead and jump into sort of this mini lecture, mini course on criminal law. And I was asked to sort of cover some requirements of crimes, actus reus, mens rea, some inchoate offenses, the different kinds of homicide, and sort of walk through practice problems. That's a lot of information. In the course that I teach in the online LLM program, it is a criminal law, criminal procedure course, two separate subjects, sort of in one course. Half of it's in criminal law, half of it's in criminal procedure. So with some of these things, we're going to try and squeeze a lot of these concepts in that which would normally take about 3 weeks into a 20-minute lecture, or I guess at this point, probably about an 18-minute lecture. But really what I wanted to do is sort of give you a flavor or an illustration of how your course with me, should you enroll in the course and take criminal law and criminal procedure, and I also teach civil procedure as well, how those courses may look like. So how I teach generally, and that's a picture of me with my license plates on my Hyundai. I'm a little bit of a fanatic when it comes to the bar exam, so my license plate actually does say bar exam, so everyone knows that as I'm driving down the street who they're dealing with. I haven't gotten in a wreck yet, and I think they're sort of avoiding me on the street as a result of that. So I know that criminal law, criminal procedure, civil procedure, any topic that appears on the bar exam can be pretty difficult. So what I try to do is sort of break down a lot of these sort of complex topics into sort of small digestible chunks. And I think the online LLM program with these small lectures, ranging from anywhere from 5, 10, maybe 20 minutes max, really does a good job of sort of breaking things down. Using multiple formats for different learning styles, including not just sort of the lecture formats, but readings, and I include a lot of visual aids, and I'll sort of demonstrate some of those things to help some of the visual learners out there. And a lot of times these charts, diagrams, flowcharts can be really helpful for non-native English speakers as well. As Dean Ioannidis said, a lot of the courses include a lot of frequent low-stakes practice, a lot of these sort of check-in quizzes to help you sort of monitor your progress. I encourage sort of collaborative and active learning, and that's why a lot of times my courses include sort of collaborative discussion sections, as well as lots of practice. And I try to make it fun and engaging because I've been doing this for, bar preparation generally for over 2 decades, and it can be a very stressful sort of endeavor, not just to prepare for the exam, but to prepare students to prepare for the exam can be a very stressful environment. So I try to make things sort of fun and engaging with the PowerPoints and the lectures. And I don't always have sort of the clearest way to talk, but a lot of times my intonations when I talk is try to make it a little bit more interesting. With that said, like I said, this course in the online LLM program is separated between criminal law and criminal procedure, and we'll just focus on the left-hand side. And I'm going to show a lot of slides, and I'm may sort of bypass a lot of the slides quickly so that we can squeeze everything in the 20 minutes. But again, the goal of this is try to give you a flavor of what you'll see in the course and almost sort of a 30,000 foot view of what's going to be in it. And so when we're dealing with criminal law, really what we're dealing with are sort of the crimes, the offenses. And so when you think about murder, when you think about burglary, right? So you're looking at sort of the crimes, how someone is charged with a crime, what are the elements of the crimes, as opposed to criminal procedure, which for bar exam purposes really focuses on the Fourth, Fifth, and Sixth Amendments of the United States Constitution. So when you're thinking about criminal procedure in the criminal law context, you're really thinking about the constitutional principles of the rights and liberties of individuals. Whereas for criminal law, you're really dealing with, in a way, sort of the meat and potatoes elements or requirements of the crimes and the offenses. Now, the way I teach the course is very obviously bar focused. And so one of the things that I want to sort of lay out here, sort of, well, what law is actually tested on the bar exam when it comes to criminal law? And so you'll hear this term criminal law, and it sort of refers to sort of judge-made laws usually, right? And so when we talk about common law, we're talking about judge-made laws, but over time, right, those judge-made laws has been supplanted in the United States by statutes, by acts, and by different things. That becomes a little problematic on the bar exam because when we talk about statutes are generally passed by individual states. But when we think about the bar exam in the US, particularly Washington, D.C., which administers the uniform bar exam, the uniform bar exam does not test any specific state law. So the uniform bar exam that one would take in D.C. is really the same that one would take in Washington State or any other of the 40 plus jurisdictions that administer the uniform bar exam. So that becomes a little complicated when it comes to criminal law, because as a default, what the bar examiners test are sort of these general applicable principles of law, which usually has its roots in common law principles. But common law principles, a lot of times, sort of came about in the 1700s, the 1800s. And so if you're trying to examine criminal law principles based on general applicable principles of law, which a lot of times has its roots in common law principles, sometimes it can be odd to examine today's hypotheticals using common law principles because there's some arcane or very old requirements. Okay, so that's why sometimes it can be difficult. Sometimes questions will tell you to apply the model penal code. The model penal code is basically, to simplify this in its sort of simplest form, it's basically a set of laws that a group of law professors, lawyers, judges have basically created to be sort of a model or sort of the main rule. Doesn't have any authority unless a particular jurisdiction or state has adopted the model penal code. And many states have adopted the model penal code either in part or in whole. And so really sort of the bar exam conundrum sometimes easier said or easier written than said. The bar exam conundrum is the states really don't recognize common law crimes. because a lot of times they're codified by statute, but the Uniform Bar Exam doesn't test state-specific statutes. So that's why you have to really know sort of those old common law principles in line with some of the model penal code, but also be able to dissect and understand express statutes that the examiners may be given to you. So that's sort of the difficulty of criminal law. With that said, let's just go to the basics of sort of all crimes. And again, really sort of designed to sort of give you sort of a big picture view. And so a lot of times whenever I'm dealing with specific crimes, I'll sort of visually break down the requirements. Here we're dealing with the requirements of crimes in general. And so every crime requires actus reus, mens rea, a concurrence, which is sort of that actus reus and mens rea occurring at the same time, and also causation. And what I'll do, as I discuss actus reus, and again, I'll have about 10 minutes remaining in this lecture, but in the program, a discussion of actus reus is really 10, 15, 20 minutes by itself. Mens rea is really a discussion that takes 15, 20 minutes. So again, I'm really giving you sort of a big, a high level view. And so when we think about actus reus, which is that guilty act, right? So that guilty act, that thing that needs to be done, right? It can exist in two ways, either an involuntary affirmative act, okay, I actually hit someone, or it's an omission of an act, but there's a duty to actually act. And a lot of times that situation may occur, right? If there's a statutory duty, one has the obligation to do something, or it's based on a relationship, parent and child. Maybe it's a duty that's expressed in a contract. So there's usually, a duty required. And if someone did not act, then that failure of that act can result in a finding of that actus reus. And so a lot of times I will include hypotheticals because I think it's important to know that for the bar exam, yes, you do need to know the law. Yes, memorization is so important, but memorization of the law is only sort of part of the game. It's so important that you be able to apply what you just learned. And so we have a lot of sort of hypotheticals and examples sort of built in throughout the programs to help you apply what you just learned. And so in this particular case, we have person A threatens B with death unless B robs the bank. B robs the bank. And then B is charged with robbery, and it tells you sort of what robbery is in this jurisdiction. Is defined as taking another person or another person's property by force. And the question is, has B acted voluntarily within the meaning of the voluntary act requirement? Again, voluntary act requirement is that one way to establish actus reus. And here, what we have is a situation where B robbed the bank because B was threatened with death. And so one could argue that that was not voluntary as a result because of that duress. Okay. And so normally there would be a series of hypotheticals maybe to reinforce the understanding of that concept from a more basic through a progressive, more difficult series of questions. Now we have mens rea, which is the guilty mind, right? We have the physical act. Now we have sort of the mental state, right? The state of mind or intent of the defendant at the time of the act, right? And at the time of the act is really important because that really goes into that third requirement, which is the concurrence, right? That physical act and that mental state really has to happen at the same time. So the question then really becomes, well, how do you prove mental state? Rarely, right, are you going to have a situation, either in real life, practically speaking, or on the bar exam, where you have a person say, I did it, right? Obviously, if you did, that would clearly establish intent. So a lot of times you have to sort of think about other ways to establish intent. Again, from just a high level perspective, right? Sort of what I would sort of talk about in the lecture. Again, there's specific videos and modules specifically on mental states and mens rea and the different kinds. And so I would go through the different kinds of mental states when it comes to the model penal code, and it really sort of how it aligns to the common law principles. And you can sort of see how there's a lot of similarities between the common law mental states and the MPC, the model penal code mental states. But there are slight differences as well. And then we spend some time sort of, identifying and comparing the similarities and the differences. Concurrence, we talked a little bit about concurrence. And so, my slides a lot of times are very varied, different. Sometimes they'll be pictures and illustrations. Sometimes, if it's important, it'll just be in like 50-point font. The defendant's criminal act must occur while he has formed the requisite mens rea for the crime. So one has to have the requisite or the required mental state at the time of the physical act. So that's the concurrence. Other words that you may want to sort of think about when it comes to concurrence or all of these, right? Concurrently, simultaneously, in unison with, synchronously, in tandem, all of those things. Then the final requirement for crimes, and this is for results-oriented crimes, where there actually has to be some sort of result or injury at the end, is that the harmful result has to be caused both factually and approximately by the defendant's act. And again, defendant's act is that actus reus. And then we would spend some time talking about, well, how do you establish actual causation? How do you establish proximate causation, right? Because it's easy to say, oh, the defendant needs to actually cause the injury, but it's different to say the defendant actually caused the injury based on this test. And when it comes to actual causation, we'll spend some time talking about the three different kinds of tests that can establish actual causation, like the but-for test, the substantial factor test, and the acceleration test. When it comes to proximate causation, right, there's really a single test there, really looking at sort of foreseeability, but there's a lot of sort of exceptions and nuances there that we'll spend a lot of time really talking about when it comes to causation. And so just as a recap from a sort of requirement standpoint, right? Actus reus, mens rea, concurrence, and causation. So that's how I would sort of talk about sort of individual crimes. Now, let's just quickly talk about inchoate crimes. Inchoate crimes or inchoate offenses are basically incomplete crimes. And again, I'm a visual learner. I like to sort of connect things to mnemonic devices to help me remember things. And I think it'll help other people too. There's three kinds of inchoate crimes. What are they? Well, there's conspiracy, attempt, and solicitation. My mnemonic device to help me remember that is CATS. Small t, CAS, conspiracy, attempt, and solicitation. Okay. And so regardless of the target crime, each inchoate crime requires a specific intent to commit that underlying crime. Like I said, conspiracy, attempt, solicitation is an incomplete crime. It's an incomplete crime because it does not exist by itself. It needs an underlying crime. So there is no crime of attempt. There is no crime of conspiracy. It's always a crime of attempt to do some other crime, or a conspiracy to do some other crime, or solicitation to do some other crime, right? And so that when you think about inchoate offenses, you always think about, okay, you need to have the specific intent, the requisite mental state to do that underlying crime, as well as the intent to do the attempt. And so one of the things that we do in the class, it's so important to sort of break down statutes And so when you think about an attempt, generally speaking, we sort of think about, okay, well, what's the mens rea required for an attempt? Again, what's mens rea? It's the mental state, it's the intent, right, with the purpose or specific intent of committing a crime. What's the actus reus? Remember, the actus reus is that physical act. It's actually committing an act, which is sort of that underlying crime. Again, if we sort of think about conspiracy from a basic definition, we always want to sort of go back to the roots and break it down to its core components. So mens rea is the intent to enter into the agreement, and mens rea is the intent to achieve that agreement. And the actus reus, right, is the entering into that agreement. And with solicitation, right, we're also thinking about the mens rea, which is the purpose or the intent that the person be aided or assisted to commit the crime. So again, big picture, when it comes to inchoate offenses, attempt, solicitation, conspiracy. Now, I know a little bit over time here, but I did want to talk about homicide because I think one of the things that I like when I teach is to walk students through a series of sort of different questions to help them better understand a particular concept. And I think sort of the crime of homicide, which is sort of an umbrella category of unlawful killings, really does sort of a good illustration of what I mean by providing a series of questions to help students sort of understand how to attack homicide questions on the bar exam. And I utilize flowcharts a lot, and because I think it just helps sort of organize all of this information into a nice, easily understandable series of items. And so I created a flowchart specifically for homicide. And I'll just quickly just walk through this. And so if you start at the top left, right, the first question you ask is, did defendant cause the victim's death? Now, obviously, if the defendant didn't cause the defendant's death, then there is no homicide. Okay, there is no homicide liability. There is no killing there by the defendant. So the next question that you want to ask, if there is a situation where the defendant did cause the victim's death, then you want to sort of understand the jurisdiction, or for bar exam purposes, right, the test question, right? Does the test question divide the murder into degrees by statute? And obviously, if it divides the degrees by statute, then you apply that statute. So we'll answer just no to this question for now, because that's more of the memorization part that you're going to have to know, as opposed to the application of applying the statute that's given to you. And so one of the big things that's tested on the bar exam is sort of your knowledge of common law murder. It's one of the biggest topics on the bar exam. And common law murder is the unlawful killing of another human being with malice aforethought, which the key there then is, well, if it's a killing with malice aforethought, how do you establish malice aforethought? And then there's basically 4 different ways to establish malice aforethought: intent to kill, intent to inflict great bodily injury, that obviously results in a death, or what's called this sort of depraved heart killing, right? Sort of this reckless indifference to an unjustifiably high risk to human life, right? It's not, just simple negligence. It's knowing that something you're doing is disregarding sort of the life of someone. And then finally, we have the intent to commit a felony, which is also shorthand called felony murder rule. And what's important here to know, again, we're thinking about mens rea, right? The mens rea here for common law murder is malice aforethought. It's not intent, right? And so, because if the mens rea is malice aforethought, which it is, there's different ways to establish malice aforethought, right? Intent to kill, intent to inflict great bodily injury, reckless indifference, and intent to commit a felony. So common law murder is not an intent crime, because obviously that number 3 factor there where it deals with reckless indifference. Okay. And so when we sort of ask this question, then did the defendant cause the killing of another with malice aforethought? If the answer is yes, then we just continue to go through this flow chart and just sort of work our way through. And so if there is a common law murder, then we ask whether that common law murder could actually be mitigated down to voluntary manslaughter if 2 situations basically exist, right? I mean, was there basically adequate provocation, or whether there was an imperfect self-defense? Okay. If the elements or the requirements for malice aforethought doesn't exist for common law murder, then that could fall under involuntary manslaughter. And really sort of the key there that we're looking at is sort of, was there criminal negligence? And so to finish off this flow chart, if there are statutes provided in that test question, then basically what you're doing is just applying that statute. And that's one of the importance of being able to break down statutes as we did with mens rea, actus reus, and some of those other parts. So those are just general definitions for first, second, and third degree murder. Now, in the remaining sort of excessive minutes that I've already went over, I did just want to go over just a sort of sample demonstration of how I would go through a multiple choice question. And I've already reviewed the law for this question, but I'll just walk through this question and tell you how I would actually answer this question, which is basically sort of the test taking strategies I believe would be very helpful on the bar exam. So what action should so you have this question. One of the things I would do is always start at the end. Start with the call of the question. What action should the appellate court take with regard to this appeal? You read the call of the question, and that really does not tell you much at all. You really don't even know what this question is really dealing with substantively. So what I would do is sort of go up one sentence and read that sentence to give myself a little bit more information. On appeal, the defendant argued that the evidence at trial was insufficient as a matter of law to support a conviction of murder. Okay, so now I know what the question is about. It's about murder. It's about common law murder. What do I know about common law murder? We just went over it, right? It's the unlawful killing of another human being with malice aforethought. There's 4 different ways to establish malice aforethought: intent to kill, intent to inflict great bodily injury. It's the reckless indifference of an unjustifiably high risk to human life, and also felony murder. So as I'm going through this fact pattern, I'm sort of thinking about those rules. So then I'm going through the fact pattern, and what I would do is sort of just go through sort of the fact pattern sentence by sentence to test his new high-powered crossbow. The defendant went out into the woods behind the home, which bordered the backyard of a house where the defendant knew several children lived and played. Seems a little reckless right there. The defendant posted a target on a tree and began firing arrows at the target. Okay, so his intent was to shoot at the target that was on the tree, but the problem is that the tree sort of, near where he knew several children lived and played. As he was testing his crossbow, the defendant heard the children playing nearby, but took no action to warn them as to the danger, right? So he knew the children were there. Even though the children began to run directly behind the target, the defendant continued testing his crossbow. The defendant accidentally misaimed and shot an arrow to the side of the tree with the target striking and killing one of the children. That was the unlawful killing. The defendant was convicted of murder. Okay, so now what we're thinking about is, okay, was there common law murder? Was there intent to kill? No intent to kill. What was the intent? Was actually just to practice his shooting of the crossbow. Was there, and if we just go back to this chart, right? Was there intent to inflict great bodily injury? No. Again, the intent was just to shoot the crossbow and practice? Was there reckless indifference to an unjustifiably high risk to human life? Sounds likely, right? So there's no intent to kill, no intent to inflict great bodily injury. Sounds like this may be good at this time. Was there intent to commit a felony? Again, there was no intent to commit a felony because, again, what the intent was just to practice his crossbowing, right? So it seems like reckless indifference would establish the malice aforethought necessary for murder. And notice what we did here. We're predicting what the answer is before looking at the answer choices. And that's what I predict everyone does when they're answering bar exam questions. Try to predict what the answer is, because if you're reading the answer choices first before reaching your conclusion, then you're going to be swayed into picking the wrong answer, because the examiners and the professor, will try to craft wrong answers to get you to pick the wrong answer. And so my prediction here, based on what we did, is that, and based on the call of the question, what action should the appellate court take with regard to the appeal? Probably deny the appeal, because there was, in fact, murder. There was murder based on this reckless indifference. And so here are the answer choices. So we're trying now to find an answer choice that best matches our prediction, which is to affirm the conviction because there was a reckless disregard establishing that malice aforethought. So A or D looks like it's the best answer there. If we were running short on time, we'd probably pick that because that's the only affirmed conviction there. But if we want to sort of wear our belts and suspenders at the same time to double check ourselves, right? What about A? Well, A, involuntary manslaughter, there wasn't criminal negligence, right? Because there was, in fact, malice aforethought. B, there was no voluntary manslaughter because common law murder gets mitigated down to voluntary manslaughter if there's adequate provocation. There was no adequate provocation in the fact pattern, or an imperfect self-defense theory in the fact pattern. And C is wrong because, obviously, as we sort of emphasize, there was no intent to kill. The intent was simply to sort of practice his crossbow shooting, which again sort of reaffirms that answer D is the right answer. And so, in a nutshell, right, that's sort of how I would recommend sort of going through a bar exam question. And then, at least in my modules, right, we spend a lot of time sort of using that systematic problem solving approach to go through the questions to help you sort of apply what you know. So I apologize for going a little bit over with that crim law session, but I thought it was sort of important to sort of illustrate the importance of applying sort of the knowledge that one would learn through the course.